required.
Counsel, I just want to understand, because one of the motivating concerns, and you can see it in our decisions under the Second Amendment, is that it is a disfavored right. And it strikes me that one of the things that your side of the case has to come to grips with is that it is a very clear constitutional right under the First Amendment. If I, for example, as a candidate for office, want to walk up to your door on private property and knock on the door and say, here, give me your vote, that's exercising the First Amendment right. But you say that it's different when it comes to the Second Amendment, that you can walk up. So when the candidate wants to walk up and he's carrying a gun, what exactly is the basis for the distinction? Because part of, again, what our precedents talk about in this area is that the Second Amendment has been treated as a sort of, a second-level right. And that's one area where given this law, I don't really see the basis for the distinction.
So we totally agree the Second Amendment is no disfavored right. At the same time, there are rules about the Second Amendment, I think rules that this court laid down in Bruin, in which you've said the relevant question is whether or not the scope of the Second Amendment's text as informed by history would say that there is a violation of the right. With the First Amendment, you've got burden tests and all sorts of stuff that this court disclaimed in Bruin at page 22. And so it's just going to apply somewhat differently. But our fundamental point to you is, yes, this is a law that which traces back to the founding with other laws like New Jersey in 1721 and 1771, laws that basically said, look, when you're bringing guns onto property, even property open to the public, the states are free to flip the default rules. Indeed, that is what happened, going back all the way to those early examples. And my friend on the other side is, I think, selectively reading those to say, the Solicitor General saying, these laws are just about poaching and the like. Absolutely not. They have no answer to what we said in our red brief, which is that these laws dealt with improved lands, and improved lands were, as Professor Hertog says, stores, seed stores, and things like that.
Right. But let me just switch gears a little bit. We talked about the tradition in Hawaii. Hawaii, given its obvious origins and its admission to the United States fairly recently, has a totally different, in some areas, tradition and practice. The law of property in particular in Hawaii, I mean, for the longest time, maybe it's still the case, is that you don't own property, you get a long-term lease as if you were a bank and a skyscraper in New York. That was the common method. And I wonder, I thought, as was mentioned earlier, it is part of the United States. And do we have different traditions in different states when it comes to applying Bruin?
No, Your Honor. I think my friend on the other side has mischaracterized our argument. Our argument is that the Second Amendment means the exact same thing in every state. No Second Amendment right to enter private property without an owner's consent. What varies is what the definition of consent is from state to state. And local law and custom help inform that. That's what I think that Justice Holmes' opinion in McKee recognizes. So just to take a simple example.
Well, just before, I don't want to lose the thought. You said part of the history and tradition is there's no right to enter private property without the owner's consent, right? Mm-hmm. Well, we know that that's not a through line, right? Because you do have a right to enter the owner's private property if you want to exercise your First Amendment rights, right?
So not without their consent, Your Honor.
Sure. I don't have to have a sign on the sidewalk before you enter my property saying, okay to come on if you're going to give me some leaflet, or okay to come on if you're a candidate. The assumption is that there is a First Amendment right. Yes, you can withdraw it. And again, I'm just trying to figure out exactly what the difference is between the First Amendment and the Second Amendment.
What I think what's doing the work in your hypothetical about the leafleting or something is the government is putting its thumb on the scale of some sort of speech and saying they're worried about some type of leaflet or the like. To the extent that they just ban it entirely, it would flunk rational basis review. The relevant right there is not located in the property in the place it's spoken, but rather that the government is coming in and affirmatively taking a position
Thank
on
you, Counsel.
that.
Well,